Kamisha Reynolds.
Morning, Your Honor, Navjot Francis on behalf of plaintiff's attorney of record.
Oh, so you're here for Lake Trust as well?
I am, and then I had two credit acceptance cases.
Oh, okay, very good. All right. Ms. Francis, you had the opportunity to speak with Mr. Thomas, and this is the original case on this matter was case 1502-2704 GC, Credit Acceptance Corporation versus James Harold II, garnishee defendants of Two-Way Transportation LLC. And that one's closed. And then also Scare Force Falconry and Bird Abatement. And I have Mr. Thomas here. So was there any resolution, Ms. Francis?
Navjot Francis on behalf of plaintiff's attorney of record. No, there was no resolution, Judge.
All right. So Mr. Thomas.
Yes, sir.
Today is a motion for hearing for entry of default against the, against Mr. James as to the fact that he is employed with Scare Force Falconry and Bird Abatement. Is that correct? Is that a correct statement? Does he work for you?
Yes, sir. He works for me.
All righty. And you received the garnishment?
I did get a garnishee disclosure. Is that the form you're just indicating?
Yep.
Okay. Yes, sir. I did get that.
And did you abide by it?
I delivered the garnishee to Mr. James. I'm just a third party here. I'm not anybody's side. I feel like if you borrow money, you should pay it back. But he's indicated to me that he's already paying like $150 a month for child support that he can't afford.
Right here is where most people misunderstand how wage garnishment really works. Thomas thinks he can wait it out or talk it through. But legally, once a garnishment order lands on your desk, you have to act. The court doesn't care if you're a big corporation or a guy running a two-person bird control business. The rules apply the same way. And while Thomas feels like the attorney's extorting him for $500, that fee isn't personal. It's part of the default penalty if the employer fails to submit the required disclosure. But it's easy to see how overwhelming this is for someone who's never been dragged into court over someone else's debt.
The garnishment, and that if I garnish his wages, he'll just go find a new job. So I'm in a position where I feel like I'm going to lose an employee the moment that I garnish his wages. Again, I'll abide by whatever the court tells me to do. This is the first time I've ever encountered this. So when I got the writ or the garnishee disclosure, I did deliver that to him. I was trying to figure out what I need to do with it, but then I got the notice to appear. And so I just figured the best place to address this would be with you in the court. I'll comply by whatever the court tells me, but the counsel here is telling me I have to pay him $500 when I send in this garnishee. I don't want to be extorted for money that I don't feel like I owe. I didn't enter into any agreement with anybody. I'm just an employee with a guy that needs a job, you know? And so she's trying to tell me I owe her $500 when I send in this garnishment, and I don't see how that's possible. So I'll abide by anything the court tells me to do. But, you know, the attorney here is trying to tell her I need to send her $500. I'm not going to be extorted, I guess. So I referred her back. I said, I'd rather talk to the judge and get my orders from you, since she's not a judge. She's just an attorney for the plaintiff.
Sure. All right. So you do realize that your best bet is always to, when you get any kind of legal documentation, and I'm not giving you any legal advice,
Sure.
This is common sense. You might want to call and show the paperwork to an attorney and go, hey, what's all this about? Instead of saying, I'll just wait. Because technically, listen, if somebody works for you and somebody files a garnishment, you need to abide by the garnishment disclosure and all those things you need to do under the law. Because if you don't, you could be on the hook for the same for the money. Okay,
Sure.
That's what they're seeking, is basically, well, then I guess we'll just get the whole judgment. We'll get all the money from you then. So listen,
which I never signed anything. I know that's how the law works, but it's
talking over top. He's not going to help you. I know. I'm just going to.
Oh, sorry.
So, and I'm not ordering that today. I'm not going to enter a default against you. What I am going to say is this: if there's funds that you have of his that that they can garnish, that Credit Acceptance Corporation can garnish. I don't know if you have an HR department or if you just do all the paperwork yourself for payroll.
I'm a small business.
Sure, no, absolutely, I get it.
The judge's patience here is key. Notice how he's not coming down hard on Thomas. Instead, he's using this as a teaching moment. The judge explains the priority order of garnishments, reminding everyone that child support always comes first before any other debt collection. He's walking a fine line, enforcing the law while sympathizing with the small business owner who's clearly out of his depth. You can almost hear the subtext, "Follow the process and you'll be fine. Ignore it and it'll cost you." It's one of those rare court moments where the judge isn't just ruling, he's educating.
So, and I don't know if they're already garnishing child support, which is a priority one garnishment, which will take precedent over things like this garnishment. I'm not going to give you any legal advice. All I'm saying is you might want to seek an accountant and or an attorney who does these kind of things so that they can correctly tell you, listen, this is how much you can send them, or maybe they're already taking, like, there's only a certain amount of money, a certain percentage of someone's paycheck that can be garnished.
Right.
And it starts off with priority garnishments and things like, and then there's a pecking order. Get in line. I don't know what your numbers are. I don't know what he makes. So I'm not speaking to any of that. Ms. Francis, are you aware? So first off, Mr. Thomas, sorry. Mr.
Yes,
Thomas, do you take out a garnishment for child support already?
Yes, sir, I do.
Okay, and that comes from the front of the court?
Yes.
And you're abiding by the front of the court's order, so you take what the front of the court tells you?
Yes, sir.
Okay. So, Ms. Francis, with regard to the garnishment for the wages, what is it that you, I guess, I don't know if there's what's available left over, is what I'm saying. So,
Well, Judge, we don't either. He didn't fill out the disclosure. If he had,
all right,
then
so
we would
yeah,
know.
I'm gonna have, so
and
Mr. Thomas, I'm gonna adjourn this matter. And I'm gonna adjourn this matter to, let's see, well, we're not here on the 4th of July, July 11th, okay? If you don't have that disclosure and all that information to Ms. Francis's office by the 30th,
Yes, sir.
all right? Then you are gonna pay her attorney's fees for having to come here today, because if you just sent that information in, and then they know, they're like, oh, wait a minute, he's already being garnished as much as he can be garnished. We have to seek some other remedy, I guess. See, that's the whole part of the disclosure, is that you gotta follow that so that they know, because they don't know how to exercise their rights if somebody who legally has money that is owed to the defendant, if they have to pay it, some of it to them, or, so that's just why you gotta follow those things. So
I understand, sir, and I apologize that I didn't send it in. Once I'd gotten it, I was trying to figure out how to proceed with it, and then I got the notice to appear, and so I just felt like the best thing would just be come here, get directions.
No,
from the
and
board,
that's why what I'm saying is have all of that sent in by the 30th so that they can proceed accordingly, okay?
I'll send it in today.
I don't know how much he makes. They don't know how much he makes. What the child support garnishment is, what percentage of his entire amount of money he made. So,
Right.
And I have no way of knowing today so that I can say X, Y, and Z, but I'm also not going to take some small, because I think the whole.
This is where the judge lets his true feelings slip. When he says, "I wish the law would be changed on this," that's not something you often hear from the bench. He's openly calling out what he sees as an unfair system, one that can make a small business responsible for an employee's debts just because of missed paperwork. That kind of honesty hits hard. It shows that even judges know some laws don't always line up with common sense. Thomas may not walk out completely off the hook, but he earns the judge's respect, and maybe a bit of the audience's sympathy too.
I wish the law would be changed a little bit on this whole, you can just, hey, you know what, if the garnishee defendant doesn't send in the paperwork or doesn't, you know what, we'll just get our whole judgment against for that guy. Like, yeah, I don't think, really, I'm trying to do a small business and I hire a guy and all of a sudden now I gotta pay his debts. Yeah, that's not happening. I think that's just.
Yeah, I appreciate that.
I don't even see how that's even It's garbage. I'm sorry. I just don't like it. But I gotta
I
follow
didn't
the
sign
law.
anything. I didn't
I
enter
gotta
into
follow the
any
law.
contract, so.
No, I gotta follow the law. I get that, but
I do, I
same-
understand.
So I'm not trying to
Well-
put this whole judgment on you. So,
I appreciate
Well,
but
that, sir.
because you
Judge,
hire.
at the same
Yeah.
time, he's saying this is the first time he's gotten a garnishment, didn't know what to do, but he just said that he is garnishing the employee's check already. So, and the garnishment was issued back in January. We sent him the notice in April. He got the failure to disclose in May, and then he got the notice to appear. So him saying that he waited just because he got the notice to appear, that was months later. All this time, we could have been getting funds from his check, and we have not. And so that's why I asked him to send the disclosure over today. We have an email on the letter that we sent him, and and then I said that we are entitled to costs. All this time we could have been getting funds, or we also did all this work just to get him here to talk to us. He didn't call us. He didn't do anything,
here.
Judge.
I'm here
So
right
that's
now.
why.
On my court date.
Yeah, I'm not I'm not, I mean, he's running a small business. He's not the one who entered into a thing with Credit Acceptance Corporation. So he didn't, he got the garnishment from front of the court is a lot easier to follow, like what they want you to do. And so, you have that, listen, so you know what, I am gonna move the time frame up because Ms. Francis told you that there's a ways you can just email her the information. So have that to her by Tuesday, 24th. If you can't email
Yes, sir, I'll get
that,
it out right away.
if you don't, I'm just saying, if you don't, Ms. Francis is gonna file an affidavit of non-compliance, telling the court that you did not have that in to the 24th. And then I'm gonna award $500 in attorney's fees for the fact that you now, after I've told you, after you are crystal
Yes, sir.
clear as to what to do, you're not moving with the speed you need to move. So
Yes, sir, I'll get it
24th
in
is
right away.
not, all right. So, and then we're gonna, if you guys work out everything and everything gets squared away, then obviously, Ms. Francis, there's no need to come back on the 11th. But if we don't, and if things aren't, I gotta make a ruling on something, then we'll do that. And then we'll do that on the 11th, okay?
Judge, can I ask just one question real quick? I will get this in today.
I may or may not be able to give you the answer because if it's legal advice, when I'm wearing a robe, it's like being a referee. I can blow a whistle, call a foul, throw a flag. I can't coach either team. So
Nope, it's nothing like
go ahead.
that. I
Yeah.
just wanted to get some clarification on the time. You said July. I'll have this in, so it shouldn't be an issue. I don't need to show up as long as I get this in. Is that correct? But July at what time? I just want to make sure I don't miss any court dates.
8:45.
Okay. All right, I will have it in today. I'll get it in right this afternoon, and hopefully that'll resolve the matter.
All right. And both of you have a good weekend.
In the end, the judge gives Thomas a second chance, extending the deadline but warning him that failure to comply this time will cost him $500 in attorney's fees. It's a fair balance between understanding and enforcement. The lesson here? Whether you're a business owner or an employee, court orders aren't optional. Ignoring them can escalate a simple matter into a financial nightmare. What do you think? Was the judge fair to both sides here, or should the law be changed to protect small employers like Thomas? Let us know in the comments. And if you found this case as eye-opening as we did, make sure to like this video, share your thoughts below, and subscribe for more jaw-dropping courtroom breakdowns, where every ruling tells a story.